when legislation is incompatible with the Convention rights, Section 4 and 10 of the Human Rights Act, and quashing orders. Declarations of incompatibility. 74. The government believes that declarations of incompatibility have been an effective way of recognising the democratic role of Parliament, by facilitating dialogue between the courts and Parliament. Under the Human Rights Act, declarations of incompatibility can only be made in relation to secondary legislation, like regulations and orders, where the Act of Parliament under which the legislation is made requires the incompatibility. Section 4 does not otherwise apply in relation to secondary legislation. Under the law as it stands, the courts can, amongst other things, declare secondary legislation invalid or disapply the provision in question. The government, therefore, asked in the consultation whether there is a case for providing that declarations of incompatibility should also be the only remedy available to courts in relation to certain secondary legislation. 75. In question 15 of the consultation, we asked whether the courts should be able to make a declaration of incompatibility for all secondary legislation, as they can currently do for Acts of Parliament. Of the 2,307 who responded directly to this question, 1,717, or 74%, responded no, and 590, or 26%, responded yes. 1,355 respondents mentioned that they believe no change is required to the current framework. In addition, 61 respondents mentioned that declarations of incompatibility should be extended to all secondary legislation. 76. The government remains convinced that reform is needed to give courts a wider ability to declare secondary legislation incompatible. However, we will not make this the only option for courts. They will retain existing powers alongside this new option by opening secondary legislation to more declarations of incompatibility. Courts will have the option to use this power as an alternative remedy. Quashing orders. 77. Section 1 of the Judicial Review and Courts Act 2022 allows courts making quashing orders in judicial review proceedings in England and Wales to include provisions suspending the effects of the order for a limited period of time, or removing or limiting any retrospective effect of the quashing. The section sets out a presumption that these powers will be exercised if it appears to the court that including such provisions would, as a matter of substance, offer adequate redress. It specifies a number of factors to which the court is required to have due regard. The section affects the available remedies where secondary legislation is held to be incompatible with the Convention rights in judicial review proceedings in England and Wales. The IHRAR panel recommended that these powers should be made available in all proceedings where secondary legislation is challenged under the Human Rights Act. 78. In question 16, we asked whether the proposals for suspended and prospective quashing orders put forward in the Judicial Review and Courts Act should be extended to all proceedings under the Bill of Rights, where secondary legislation is found to be incompatible with the Convention rights. Of the 1,290 who responded directly to this question, 1,038, 80%, responded no. 252, or 20%, responded yes. 654 respondents mentioned that they believe no changes are required to the current approach. 79. The government's view is that it is right that suspended and prospective quashing orders should apply to human rights cases, and is satisfied that this is appropriately provided for in the Judicial Review and Courts Act. Therefore, there is no need for further legislation on this matter in the Bill of Rights. Remedial orders. 80. Section 10 of the Human Rights Act provides that remedial orders may only be used where ministers consider there are compelling reasons to do so. It was included in the Act to provide a means of addressing incompatible legislation more rapidly than is generally possible through primary legislation. Remedial orders are generally subject to a type of super-affirmative parliamentary procedure, although there is a procedure for making and commencing an order before a draft is approved by Parliament where the matter is considered urgent, known as the urgent procedure. This is to facilitate a swift response to adverse judgments presenting significant issues, even when Parliament is not sitting. 81. In question 17 of the consultation, we asked if the Bill of Rights should contain a remedial order power, outlining 4 options. Of the 1,320 who responded directly, 333 respondents mentioned option A, similar to that contained in Section 10 of the Human Rights Act. 152 respondents mentioned option B, similar to that in the Human Rights Act, but not able to be used to amend the Bill of Rights itself. 148 respondents mentioned option D, abolished altogether, and 43 respondents mentioned option C, limited only to remedial orders made under the urgent procedure. 766 respondents said that there is no case for change. 82. We have carefully considered the recommendations of the IHRAR panel and the responses to the consultation and have decided that remedial secondary legislation remains an appropriate measure when there are compelling reasons to use it in certain specified circumstances. We are adding certainty about the scope of the power by making clear that remedial secondary legislation cannot be used to amend the Bill of Rights itself, as the IHRAR panel recommended.